Hi there, I'm Savannah Mexto with Mannor Law Group, welcoming you to another Webinar Wednesday with esteemed elder law and estate planning attorney, Robert Mannor. Navigating the loss of a spouse or partner is already so difficult, but when considering the new legal and financial implications, the weight of that loss can be compounded. Today's Webinar Wednesday is especially for widows or widowers who are now managing the affairs and finances after their loss. Before I pass the mic to Bob, I'd like to cover a few housekeeping details. First, even though Bob is an attorney, today's webinar will not give specific legal advice. If you have a question about your unique situation, please contact us after the webinar. If you have a general question during today's presentation, please use the question box. We will save time to review questions during the webinar. If for some reason we don't get to your question, we will contact you after the presentation. And of course, today's presentation will be recorded, and the replay will be sent out tomorrow so that you can share this with family, friends, or anyone who you think could benefit from hearing this information. Now, why should you listen to what the folks at Mannor Law Group have to say? First, note that we're a nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Attorney Bob Mannor is nationally board certified as an elder law attorney by the National Elder Law Foundation. He is one of only 19 attorneys in Michigan to achieve this designation. Bob is also a leader among elder law attorneys in Michigan. He is currently chair-elect of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. And of course, Mannor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Now, without further ado, I'd like to welcome attorney Bob Mannor.
Hi, folks. This is always an important topic to cover. After we lose a spouse, sometimes we just assume that everything is going to be automatic, because if we've been married for 30, 40, 50 years, something like that, that we expect that, well, the house is in both of our names and the bank account is in both of our names. But there are some things that you're really going to want to think about at this time. And what we usually say is there's a few things that we need to take care of right away. But for most things, we can let things settle down for a couple of weeks, but we don't want to put it off for too far before we make sure that we get everything set for this next stage of life. So the first scenario is if you haven't done estate planning. So I've met with couples from time to time, and honestly, it's usually the man that says, oh, we don't have to do this now, we can do it after one of us dies. I think that's a bad idea, honestly. I think that you should do the plan together. There's a lot of things to think about, and sometimes it just seems like it's obvious, hey, we're just going to leave everything to the kids or things like that. But there's more to it than that. It's more to it to the extent of, well, who's going to help us in our old age? Who's going to step up? Who's going to be there for us if we need somebody to help us with our finances at some point? Well, if we need somebody to help us go to the doctor or drive us to the doctor, things like that. And so these are things that we really should be talking about together, especially if there's anything unique, such as it's a second marriage or anything like that. It becomes even more important that we really have a plan that everybody understands. It's important to have both spouses give consideration to it, and there's some really serious questions that should be addressed. However, it is sometimes the case that either because of procrastination or choice, just never got around to it, that you haven't done an estate plan, or that when you did, it was when the kids are young. And so it was many, many years ago. Well, if that's the case, after one spouse dies, it's definitely important now to get an estate plan for your current circumstances. So what is the value of an estate plan under these circumstances? Well, it's going to be more important now because, well, there are a lot of protections for spouses upon the death of the first spouse. Those protections don't necessarily run as much to the family, to the kids. And so where it may have seemed like there wasn't much that had to be done to make sure that you still had access to all the assets and things like that after the death of a spouse. That's not going to be the case after the death of the second spouse. So it's even more important now to make sure we have a plan in place. So I've got a few different things listed on here. This isn't everything, but it's a few of them to think about and why it's important at this point to make sure that we have a plan in place. Well, the first thing is to stay out of court and to avoid probate. And this is both during your lifetime and after death. So a lot of people say, well, I don't see why my estate would have to go through probate. I have a will. Shouldn't that be enough? I have a will. It might be 30 years old, 20 years old, but it shouldn't that be enough? And the answer is a will actually goes through probate. A will doesn't have any legal effect until the probate court gives it effect. So a lot of times we say, well, I don't see why we need to go through court. And the answer is most of the time you don't. If you've got competent and trustworthy people, we can make sure that we have arrangements set up so that it doesn't have to go through a court process. And so we want to avoid probate upon death. The other thing is we want to avoid probate probably even more during your lifetime. So this is one of those things that we don't really like thinking about, especially after our spouse just died. But now is the time that we really have to make sure we have a plan in place for what if you get sick? What if you had a stroke? What if you start experiencing some memory loss or some dementia or Alzheimer's or experience any of the other sort of dreaded diseases? Well, we're going to need something in place to make sure that decisions can be made. And if you don't have that, guess what's going to happen? If any of those things happen, you have a serious stroke, you have dementia, you have memory loss, you have Alzheimer's, or just physical restrictions even, pretty good chance that somebody's going to need to be able to make those decisions for you if you're not able to do that on a daily basis. And if you haven't predetermined that, if we don't have the proper legal documents in place, what's going to happen? Well, we're going to have to go into court and get a guardianship or go into court and get a conservatorship in Michigan. And then a judge is deciding who's going to be in charge of you, who's going to be in charge of your medical decisions, who's going to be in charge of your financial decisions. This is a serious thing. And so a lot of times we just assume, oh, well, the judge is going to appoint family. And that's really what they should do in most cases, right? It should be obvious that, okay, well, if my children step up, then they should be the one appointed. And that is how the law is written. We've just seen lots of times recently that that's not what happens. They're trying to fix this. The governor has a elder abuse task force that's trying to deal with guardianship abuse. There's even a movie out there right now that some of you may have heard about. I think the movie's called I Care a Lot. And it's definitely a Hollywood version of things, and it goes to an extreme beyond what is realistic. But there are some elements to it that are, do kind of model reality in some cases. There was, it was kind of, I believe it was modeled after a person out in Nevada who was getting appointed as guardian for all these different people without their consent, without the family's knowledge, and selling their house, putting them into a assisted living or nursing home, and getting realtor fees, paying for care. There was a case in Michigan that some of you may have heard about, where a family member stepped up to be guardian, and the judge appointed a stranger. The judge appointed a professional guardian instead of that family member. The guardian then hired her husband's law firm to handle all the legal work. The guardian then hired her own care company to provide 24-hour care. They ended up spending over $400,000 in about 6 months, which is absurd. That's what happened in that case. In fact, it got so extreme that the guardian put up a privacy fence around the parents' house so that the family couldn't see in. So the family couldn't see what was going on because there was a daughter that lived next door. And that was the one that was actually trying to get appointed guardian. And this was real life. This has actually happened in Michigan not that long ago. Now, fortunately, it got the attention of some media, and it eventually got the attention of the Attorney General and the governor's office. And so ultimately, that guardian was removed, and another guardian, who was also a stranger to the family, got appointed. The judge got removed from the case. It got taken over by the chief judge. But the bottom line is that $400,000 had already been spent, and these people had been kept away from their kids for all this time. So we just don't want, if we got competent, trustworthy people that we could appoint ourselves, why would we want a court being involved? Even if the court appoints the right person, now they have to go into court and do all the red tape and fill out all the paperwork and send in the reports and show up in court once a year if it's a conservatorship. And so the idea is, if you know that you've got people that you trust and people that you love, why wouldn't we want to put that stuff in place? Why wouldn't we want to put those legal documents in place at this time, rather than wait for, well, we hope that nothing bad's going to happen. We hope that we don't have a stroke. We hope that we don't get Alzheimer's or something like that. You can get those things in place so that we don't end up having to go get a guardianship. And then part of that, one of the things that I find is people will sometimes go to attorneys they just draft these documents and say, okay, here's all your documents, and then that's the end of it. But there's no education, there's no family training, things like that. So when something happens, there is a stroke, and a nurse or a social worker or somebody says, oh, you better go get guardianship, and they go into court and get guardianship anyway, even though they've already got proper legal documents in place, and that they don't need to go into court. They don't need to have the probate court involved in their lives and their decision making and their financial decision making and their medical decision making. That's one of the things we do in our office. We want to make sure that this is not just something where you come in and sign documents without really understanding what you're signing. We're going to want to make sure that we, first of all, tailor them to your specific needs. And then we really want the family to get educated about what these documents are and how they work and when they might need to use them. We've instituted for years now where we have a family education meeting. And so the family education meeting is where our clients can come in, but ideally it's the kids coming in, the people that you've appointed to take over, be your executor, take over making decisions if you can't make your own decisions. I want them to be educated. And so recently we created a video for education. We're going to do this periodically, and we'll update that video probably a couple times a year, with the idea that things will change, but to get people prepared, to get the kids prepared for, well, what do you do? What legal documents do you need in the event that there was a stroke, in the event that there is a death? How do you access the money? How do you make medical decisions? If somebody says you have to run into court and get a guardianship, how do you articulate that that's not accurate, that we have proper legal documents and we don't need a court order for that? Because you'll hear people say that doesn't matter what legal documents you have, you still have to go into court. Well, they're wrong. That's not accurate. In fact, in the court rules, it specifically says if you have these legal documents and that person's competent and capable, they shouldn't issue a guardianship. The judge should actually say, no, we're not going to issue a guardianship. So this is really important, that especially after your spouse dies, that you make sure we have these things in place and make sure that we have the right people in place for this. One of the things I put on here, I think it might actually be on the next slide, is making sure that you have the right people. So occasionally we'll have folks that say, well, I need to list my oldest son because he'd be mad if I don't. Well, is your oldest son the right person? Is that the person who's going to be willing to step up? So he might be perfectly capable, but is he willing? Is he going to actually put in the time, visit you, understand what's going on, take good care and make sure that, that he's actively involved? Or is it somebody else in the family? Is there somebody else that is actually going to be more willing to put in the time and the effort, and are they just as trustworthy and just as capable? So sometimes we can see that after the death of the first spouse, because we see, okay, well, when my spouse died, this is the person that stepped up and came to the funeral home with me. This is the person that stepped up and helped me get that life insurance paid off, and things like that. So sometimes we, after the death of the first person, the first spouse, we might say, you know what, I had my oldest son on there, but really it's my youngest son or my youngest daughter or grandchild, whoever it is, that we say this person really is the one that's going to be willing and able to do it, and they're competent and capable and trustworthy. And so I think we should change those documents to have it be the person that actually does it, that actually steps up and puts in the time and puts in the effort and puts in the care for it. So that's one of the things, to just make sure that we don't end up in court. We have the right people appointed to be able to help you if you get sick or after your death. So there's a few other things listed on here. of course, is going to be getting your spouse's assets in your name. Now, a lot of times, if you own the house together, it's just automatically going to go to the surviving spouse if the deed was written properly. We see in our office all the time that deeds are not written properly, especially if it was transferred between family members. What you don't want to do is add your kids' names to the deed. So what a lot of people, we get this advice, people getting this advice all the time. They say, oh, well, your spouse died, now you need to add your kids to the deed to your house. Absolutely not. That's probably the worst case scenario. The worst thing that you could do is add your kids' names to the deed to the house. We had somebody in I was meeting with yesterday, and we had that's the advice that they got. It's caused all kinds of problems for two reasons. Number one is it's a bad idea to add the kids' names to the house. Secondly, the deed was drafted by I'm hoping not an attorney, because it didn't have the proper language on it. One or two words different is going to make all the difference in the world on a deed. A deed is one of the most easy ways that you can screw things up. So it looks like a simple form. It's 1 page long. How could you screw this up? But the bottom line is, if you don't have the right words on there, does it say joint tenants? Does it say tenants in common? Does it say tenants by the entirety? Does it say nothing? If it says nothing, you've probably got a problem. If it doesn't say how you own the property, it's almost certainly going to create a real bad issue for you. Okay, so and then the other thing to think about is, okay, now I don't have a spouse anymore. I got to think about, as I get older, if I get sick, how am I going to pay for care? And there's things you can do in your legal documents to make sure that we have a process. There's a number of programs through the Veterans Administration, through Medicare, through Medicaid, that can help pay for home care or for assisted living or for nursing home care. But we may need to make sure that your legal documents are set up properly for that. And a lot of attorneys don't really think about that. A lot of attorneys are really focusing on, well, what happens when you die? That's why they do a will or they do a deed or things like that. Well, it's just as important to talk about, well, what happens for the rest of your life? Okay, so we got to make sure that your spouse's assets get properly titled. If it turns out that there was an account that was only in your spouse's name, or hopefully not, but if the house was only in their name, we got to make sure that gets transferred. We got to make sure that the life insurance gets paid off if there was life insurance. We got to make sure that we have a plan in place so that it's not going to be difficult for your children when you pass. We got to make sure that there's a plan in place in case you get sick, or in case you have a stroke, or in case you get dementia or something like that, memory issues. So a similar thing would be, well, what if you already have an estate plan? So a lot of people say, okay, well, we worked hard, we did this, we got an estate plan together, we have a will and a trust and a power of attorney and a healthcare document. So when one spouse dies, we don't have to do anything, right? And the answer is no, really, we should update some things. So likelihood is your spouse might be listed as your primary decision maker. Your spouse might be listed as a co-trustee of your trust, may be listed as the power of attorney that you've appointed, may be listed as the person who would make medical decisions for you. And we probably should update that. It's going to be a heck of a lot easier, even if there's backups listed in the document. So it says my spouse, or if my spouse is not available or deceased, then my daughter. Okay, that's great. It should say that. I hope there's backups. Maybe we need more backups. We like to have 2 or 3 backups if that's possible. But the second thing, it's going to be a heck of a lot easier for your daughter to use that power of attorney or to use that trust if they're listed as the primary person and not the backup. Otherwise, it's going to go through a whole other level of scrutiny to say, okay, well, you got to prove that the other spouse is deceased, or you got to go through this other process, and it's going to slow down their ability to use these documents. So I really do recommend that upon the death of the first spouse, we update those documents so that if you have your spouse listed as your decision maker on your trust or your powers of attorney or your will, the will is probably less important, but the other documents, then we pick somebody else to be the primary. So updating your power of attorney and your medical documents, updating your trust. Consider adding a co-trustee. Now, this is certainly optional. So if you don't expect that you're going to have any need for any help or any assistance in paying your bills or handling your finances anytime in the near future, then you'll just be the trustee of your trust if you have a trust. You don't need to have somebody acting for you currently. But for some folks, this is the time to think about it, to say, well, if I go on vacation, or if I'm going to go to Florida for 3 months, or if I get sick, I want my daughter to be able to go to the bank for me. I want my daughter to be able to sign a check for me. I want my daughter to be able to make deposits for me, or to have access to make sure that everything's balancing and things like that. And the answer is not to put her on the account. I know a lot of people would think that, oh, well, just add your daughter's name to the account. Again, that creates a series of problems, because now your daughter owns the account. If you add her name to your bank account, your daughter owns that account. We don't really want her to own that account. That creates its own set of legal problems. What we can do is we can have her as a co-trustee for you. What does that mean? Well, that means that you are still in charge. You get to do whatever you want, but she has access to, or your son has access to, or your granddaughter has access to, whoever it is that you appoint as your co-trustee has the ability to pay your bills for you. But that doesn't mean that you don't have that ability. You're not giving up anything. You're just saying they also have that authority. So it's about access and control versus ownership. We don't want them to have ownership. While you're alive, they shouldn't have ownership. That's what happens when you put their name on the account. What we want them to have is access, the ability to write a check, access to information, okay? And that would be where we consider making them a co-trustee. Probably prior to your spouse's death, the two of you were co-trustees. Now, when your spouse died, maybe consider listing one of your children as co-trustee. And then I mentioned this earlier about deciding who your helpers should be. Sometimes we've gotten new information. After the death of our spouse, we saw who stepped up, who was the real helper, who was the one that was our right-hand person that just made sure that things got done and got taken care of. Well, maybe that should be the person that you appoint to be in charge of things. All right. This is an important thing that a lot of people don't think about. So this is taxes, specifically capital gains taxes. So I know when I say the word taxes, sometimes people's eyes glaze over, but this is an important one. So here's what I mean by capital gains taxes. If you buy something at one price and sell it at a higher price, the IRS says we get to tax the difference. So if you bought a share of stock at $20 and you sell it at $40, as you might guess, you have to pay taxes on the $20 difference. You bought it at 20, you sell it at 40. They say, okay, well, that's a gain. So then they look at whether it's a short-term gain or a long-term gain to determine how much in taxes you have to pay on that. And there's actually ways to avoid the taxes and roll it over and do other things. But the bottom line is we have to think about this. So they look at what you bought it for and what you sold it for. What you bought it for is called your tax basis. Okay, that's the term we use, tax basis. So if you bought stock at 20 and you sell it at 40, your tax basis is 20. And when you sell it at 40, they say, okay, you have a gain of $20, so you're going to pay taxes on it, not income taxes, but capital gains taxes. What a lot of people don't think about is that also applies to things that aren't stock, anything that increases in value, like your cottage. It typically doesn't apply to your residence, your house, because there's special exemptions for your personal residence, okay? But if it's a second property, or if you have commercial, property, or you have a rental unit, or you have a cottage up north, or you have a condo in Florida, or you have any second property, and it increases in value, then there's going to be capital gains taxes on it. And again, there's ways, if you talk with a tax professional, that you might be able to roll that over into a new property or things like that. But we need to be concerned about that purchase price, what they call the tax basis. What's interesting about this is an interesting part of the law that says when you die, the people that inherit from you will get what's called a step up in basis. And the step up in basis says, okay, even though mom bought that stock at $20 or bought the cottage for $20,000, and even though now it's worth $100,000 or $100,000, you're going to the kids, if they inherit this, are going to, as long as it's done through a will or a trust, or it's considered an inheritance, they will get the property. Their tax basis will be the date of death value, so $100,000 or $100,000. That's really important, because if they didn't get that step up in basis, if they didn't get the date of death value as their tax basis, then that means when they go to sell it, they're going to have to pay taxes based on the purchase price that you had maybe 30, 40 years ago when you bought the cottage or when you bought that stock, okay? So this is a really important tax element. Here's where it comes into play when we're talking about a married couple. So with a married couple, you have the possibility of getting a half step up on the death of the first spouse. So let's say you bought stock at 20, it's now worth 40, and you owned it together. Your spouse dies, you can get a step up, a half step up, meaning now your tax basis is 30 instead of 20. So if you go to sell that stock, you don't have to pay for taxes on the whole 20, you would only pay taxes on 10. Okay, I know that may have sounded a little complicated, but it's really important to know and to make sure that we get this taken care of, and we talk to a tax professional or meet with a lawyer and make sure that we get this taken care of so that we know what our tax basis is, so that in the event that we sell, we're not paying too much in taxes, okay? Very important. And then, of course, planning for care. If your spouse is gone, you may have even cared for your spouse. You might have been the caregiver spouse. And if your spouse is gone, well, they're not going to be here to care for you and take care of you at home, make sure you get food and get dressed and all those things. And so now we got to figure out how to pay for care. As I mentioned earlier, there's a lot of different programs out there, from Medicare to Medicaid to Veterans Benefits and some other programs that you might be able to qualify to help pay for care in the home, to help pay for nursing home care. But in order to do that, we need to make sure we have proper authorizations or permissions in place. A lot of lawyers don't think about this. A lot of lawyers are planning for what happens if you die, and that's important, but we also have to plan for what if you don't die, meaning if you get sick and you need care, and we want to be able to qualify for one of these programs. So this is a very important time after the death of the first spouse to make sure that we have those plans lined up. Make sure, ideally, that we have a family meeting where the family knows what the plan is. The family meets with the lawyer too, so that we kind of talk through what's going to happen if mom gets sick, what's going to happen if dad has a stroke. And we talk through that with at least the relevant family members, the ones that are going to need to step up. This is a really interesting thing, and it's kind of a difference between different types of lawyers. I've had lots of lawyers that say, oh, the family can't come into the room. I can't talk to the family. I'm only going to talk to mom. I'm only going to talk to dad, and the family have to sit out in the waiting room. Well, I look at it the opposite way. So yes, I have to be worried about conflicts of interest. I have to be worried about undue influence, and we take good measure to make sure that we don't feel like that there's any evidence that mom's being pressured to do one thing or another. And if in fact we're excluding kids or things like that, we might have to have the family sit out in the waiting room for a little bit. But at least for part of the meeting, and often most of the meeting, we want the family there. We want them to understand what their role is. We want them to understand what they might need to do and what options they have to make sure that you're protected, make sure we don't lose everything if you get sick. And so this is as important time as any to have that family meeting to make sure that we've got things in place and things are going to go smoothly. And then finally, planning for your children. So this is something that a lot of people think, well, what do you mean planning for the children? I die, they just get my stuff, right? Well, that's fine. That's actually perfectly fine. You can have it that way. But there are options in planning to say, well, but I have a special needs child. I have a child that's on Social Security disability, or I have a child that might be getting divorced and I don't want them to lose their inheritance to a divorce, or they have some financial troubles and I don't want my inheritance to be eaten up by their financial troubles, or they have medical issues that I don't want my money to end up getting having to be eaten up by all their medical costs if they could get other programs to help pay for it. So there's a number of things that you can do to protect when the kids get the inheritance, they can receive it in a way that isn't going to be affected by divorce, isn't going to be affected by creditors, and isn't going to be affected by medical expenses. And so this is as good a time as any also to say, okay, let's plan now, because one spouse already died, the remaining spouse will die at some point. Why don't we look and see whether or not we want to do any planning to make sure that when the kids receive the assets, that they aren't squandered, or they're not lost because of a disability, or they're not lost because of debt or things like that. Okay, so that's basically my presentation for today. I check and see if there's any questions, and then we're going to have Savannah step in and tell you how to get some more information.
Thanks, Bob, and thanks to everyone who joined us today. As Bob mentioned, we do have a way for you to contact our team. We actually have two ways. Of course, you can always give us a call. Our phone number is 810-694-9000. I've actually put that phone number in the chat right now. Also in the chat, I've put a link. The link, when you click it will take you to a calendar. You can choose a day and a time when a member of our team can call you. Maybe you have a few questions, maybe you have some concerns, maybe you're just kind of wondering some things and want some general information. Well, that's what we're here for. There's no risk or obligation or cost for that call. We're here for you. After the call, then you can decide if you'd like an appointment with our team, or maybe there's even a different attorney or somewhere else who could help you better than we can. But that's what we're here for, that first call, just to get some information and let you get information from us. So again, you can call 810-694-9000, or you can look in the chat box, and I've gone ahead and put that link in there for you for the calendar. I'm also going to be sending you an email in about 10-15 minutes that will also have our phone number and link and just some next steps. And then tomorrow, I'll be sending you the replay of today's presentation. And again, you can watch that again or share it with friends or family or anyone who you think could benefit from hearing this information. Thank you so much for joining us today. We will see you next week.